Good afternoon. I am immigration attorney Christian Zeller, and I am NMSU's Immigration Legal Counsel. And today I am broadcasting from my home office in the Tampa area in Florida. I wish I would be on campus as I have been so many times, but given the health crisis and current circumstances, we have to broadcast remotely. Now, before we begin our postgraduate immigration option presentation, a couple of housekeeping rules. You're all in listen-only mode, but of course, I do want to answer all of your questions. So I believe you have a feature on your screen where you can raise your hand, and if you have a question, please do raise your hand. I don't know whether it is feasible to answer your question during the presentation or whether we do it afterwards. But anyway, I will answer your questions. So when you do have one, just raise your hand and then we'll take it from there. And with that, let's get right into the presentation. Now, we will be talking about non-immigrant visas, and we will be talking about immigrant visas. And non-immigrant visas are those that allow you to come to the United States in a certain classification, and once that purpose of that visa is over, you have to leave the country, such as with an F1 visa, an H1B, a TN, and what have you. And an immigrant visa is, of course, a green card, and that's the document that allows you to remain in the United States permanently. Now, when we go through this presentation, it's the same presentation that I give twice a year at NMSU. You will find some things in red. And what is in red today either has to do with COVID, or it has to do with other immigration restrictions, or it has to do with the election. So on some of those things, I will have a rule for you, and on some of those things, we're going to have to speculate. But let's see what happens, and let's dive into it. First, the F1 and the F2s, the F1s, which most of you have, everything is in red. So I think we ought to spend a minute at least on that. All of you know that the universities, of course, around the country had a severe setback due to the COVID-19 health crisis. What that means is that many institutions had to give up or at least severely restrict their in-person tutoring. So there you may be at a hybrid institution, or you may be doing everything online altogether. So that is something you may want to keep in mind. But what you need to know is, whatever you hear out in the street, the guidance for now remains the same. And by guidance, I mean the March 13th, 2020 guidance that was issued by ICE. I know your foreign student advisor has that. I know our HR department has that. And likely you have seen this guidance, and your international department is keenly aware of what those rules and regulations are. So at this point, there is nothing to worry about. Nothing has changed. What has changed, of course, over time are the various travel restrictions for international students. And from most countries, there are no travel restrictions, but from some countries there are. And those include the People's Republic of China, Brazil, all of the Schengen countries in Europe, England, Wales, and of course, Ireland. So if you come from any of those countries, as a student, you can still come to the United States, but you might need a national interest exemption. If you come from England, Wales, Ireland, or from the Schengen countries, you don't have to apply for a separate national interest exception if you have a valid F1 visa. But if you come from any other travel restricted countries, you're going to have to apply for the national interest exception, and you will get it. The last presidential proclamation was very, very clear that students come within the national interest exception. And that, by the way, also applies to you wanting to apply for a new student visa overseas. Under the national interest exception, it is possible to get appointments at the various consulates in order to have a student visa issued. Now, with the student visa, of course, comes a very, very important benefit that many of you are taking advantage of right now or will be taking advantage of after graduation, and that is either OPT or STEM OPT. STEM OPT is, of course, if you graduated in sciences, technology, engineering, or math, you don't only get 1 year of regular OPT, you actually get an additional 24 months of STEM OPT. In order to get that, just in case you don't know, you have to be in valid OPT to get your STEM extension. You can't just run out a regular OPT and then apply for STEM. You have to be in valid OPT status in order to apply for a STEM extension, and you have to have a STEM degree, of course, or if you have earned a STEM degree in the last 10 years, then you can also get an OPT STEM extension. Now, what has changed in STEM for us internally is I'm very, very pleased to announce that Nmsu has now started hiring STEM graduates in the various departments, and that is, of course, great news because it is something that we only started this year. The reason is that every STEM employer must be a participant in E-Verify. And for those of you who don't know what that is, E-Verify is a collaborative program between the Social Security Administration and the Department of Homeland Security that allows an employer to ascertain whether a person is allowed to work legally in the United States. And any employer offering STEM OPT jobs must be a member of E-Verify. And again, I'm pleased to report that Nmsu is a member of E-Verify. Another thing that's important in this context is that there must be a true employer-employee relationship when you work in STEM. And that means that you can't have your own business when you're a STEM employee. You have to actually have an employer. And I put changes there, and that's in red. And that is because the current administration has proposed changes to the employer-employee relationship. And I can't tell you how that will impact you yet, because that is a rule that is on the way. And while we're talking about rules, when it comes to the change in administration, and there likely is a change in administration in January, there are several things that you can count on, and there are some things you can't count on. Keep in mind, although the election was some time ago, the change of administration will not take place until January 20th. So anything that we are talking about today, that's the law today, and some of those things, whether we like them or not, are here to stay regardless whether there is a change in administration or not. Let me explain. You have to distinguish between what is an executive order and what is a regulation. An executive order is something the president can sign and the next president can vitiate it with the stroke of a pen. So if President Trump signed an executive order to do X, then President-elect Biden, once he is sworn into office, can sign this away by way of an executive order. So some things will go away likely on January 20th. Doesn't mean that they will, but that is a possibility. However, if there has been rulemaking underway, meaning that a regulation has changed by way of the proper rulemaking process, in other words, the Department of Homeland Security has drafted a rule, has allowed the public to comment on it for a 60-day period, and has then finalized that rule, that is something that cannot be done away with the stroke of a pen. If the next administration wants to change a rule, you better count on a year or two before that happens. If they would have to, because they once again would have to propose a new rule. They would then have to go through the comment period, and then they would have to implement that new rule. So just a word to the wise here, just because there is likely a change in administration does not mean that there will be all these changes that we don't like right now, that they will be reversed on January 20th. So, and that applies to the employer-employee relationship. Now, back to the STEM. If a STEM employee has any material changes in their STEM training program, that must be reported to the designated school official, because that has to be enumerated then in your CVIS account. Also, STEM is a training program. It is not a job, and you have to distinguish between that. If you just have regular OPT, you can work in a job that's a function of your degree, and you can do whatever you like within that. You earn your money, and you actually replace someone, because it is a job that you have. As a STEM trainee, you are not replacing a US worker. You're actually being trained on the job in your discipline. Now, when it comes to STEM, you have to work a minimum of 20 hours a week. Unemployment becomes a headache under OPT. If you are in regular OPT, you can be unemployed for up to 90 days. And if you're in STEM OPT, you can be unemployed up to 150 days. And that is, of course, an issue right now because of the economic downturn. And I'm sad to report that we have also found out that certain or a few OPT holders have been punished by the Department of Homeland Security for not working. They are basically student visa violators. So if you're in regular OPT and you're nearing your 90 days unemployment, if you should be in that unfortunate circumstance, and I strongly encourage you, then go volunteer someplace. Because if you're in regular OPT, volunteering will count towards your OPT work time. However, for STEM applicants, that does not apply. As a STEM graduate, you must actually work. And with that, I'd like to switch it for after you graduate from Nmsu, or maybe you have graduated already. And obviously the visa that is most talked about, and the visa that also seems to be the most controversial, is the H-1B visa for applicants who want to work in a specialty occupation, and the H-4 visa for their spouses and minor children. If you look at the three dudes down there in your corner, those guys are called the Basics. I'm told they are a rock band from Australia. I put them on there because we're talking about the basics, but of course we'll talk about the basics of the H-1Bs and not about these three guys, but they'll follow us through the H-1B presentation. So as a basis, you have to have a degree in order to qualify to apply for an H-1B. And by a degree, we mean the minimum of a bachelor's degree. And of course, you have to have a job offer. And that is very, very important, because it is not you who is applying for a job. It is actually your employer who is applying for you. You are merely the beneficiary of someone else's petition. So you provide the degree and the expertise, and someone else provides the job. And the person providing the job is actually the person filing the H-1B petition. And your job has to be what's called in a specialty occupation. And typically a specialty occupation is an occupation that requires the attainment of at least a bachelor's degree. So if you graduate with a degree in electrical engineering and you have a job offer as an electrical engineer, that would be a specialty occupation application. Another important part of the H-1B visa program is that you have to be paid a certain wage. And there are two types of wages in the H-1B context that the Department of Labor talks about. One is called the actual wage, and the other is called the prevailing wage. And the actual wage is the wage that the employer offers to pay you. And the prevailing wage is what the Department of Labor says you have to be paid. And by law, you have to be paid the higher of the two. So again, if you graduate with an electrical engineering degree and your first job offer, that employer offers you $60,000 in your first year as an electrical engineer, then that is the actual wage. Now, if the Department of Labor says the prevailing wage in Las Cruces or in Albuquerque or in Kansas City for an electrical engineer is $65,000, well, then that employer would have to pay you 65 because the 60 is not gonna do it. Now, if the actual wage is higher than the prevailing wage, let's say the Department of Labor says an electrical engineer only needs to make $45,000, the employer still has to pay you the 60,000 he or she offered you. So you have to be paid the higher of the two. Red, caveat, changes are coming. We don't know how severe those changes are because the current administration is trying to go through this by way of rulemaking. And as I said before, if they succeed by way of rulemaking, it could be quite some time before that, whatever they do, is undone. If it goes by executive order, well, then it'll be gone by the stroke of a pen, if the next administration wants to do that. Now, the proposed changes are a redefinition of what a specialty occupation is, which absolutely makes no sense, and there's no point in us discussing it, and that would certainly require rulemaking and probably some legislative act by Congress, and I don't think we'll have to be afraid that that is going to happen. But I'm more concerned about the wages. You may or may not have heard that the current administration has been advocating to significantly raise the wages for H-1B applicants. Now, if you're an H-1B applicant, that's of course great news, but don't jump up and down too soon because you're going to have to find an employer who's going to pay that wage, and that's going to be the tough part because the new wage proposals are so exorbitant and they are so high that many companies would not be in a position to hire someone in the H-1B classification. But again, I don't want to make the horses shy at this point because it has not happened yet and we don't know whether it will happen, but I think something would be amiss if I would not at least alert you to what is going on behind the scenes. Now, the H-1B also has some controversial basics, and I don't understand why this is, but it is what it is. So the H-1B visas, unfortunately, have what's called an annual numerical limitation. That means there are only a certain number of H-1B visas available each year. Specifically, there are 65,000 visa numbers available each year for persons who have earned at least a bachelor's degree in a specialty occupation, of which we deduct 5,400 visa numbers that go to Singapore under a free trade agreement we have with Singapore, and another 1,400 that go to Chile under a free trade agreement we have with that nation. If those numbers are not used up, the Chilean and the Singaporean numbers, they get added back into the 65,000. And then we have an additional 20,000 numbers available for persons who have earned at least an advanced degree from a US institution. And an advanced degree is everything of a master's degree or higher. So something that applies to very many of you. So you tell me how many H-1B visas we actually have. I don't know, but those are the numbers. Every year, what I do know is it's never enough. Then there is this cap. There's the cap of the 65,000 and there's the cap of the 20,000 of the advanced degrees. But in some cases, there is no cap. And this is something I think you need to know, because if you get a job offer from an institution that is not subject to the H-1B cap, then that institution can apply for your H-1B visa whenever they like. They don't have to wait until visa numbers actually become available or check whether if there are visa numbers available, because they are cap exempt. And there are three types of scenarios where that applies. One is if you are employed at an institution of higher education. So if you were to be employed at Nmsu, for example, then you would be cap exempt, and Nmsu can apply for your H-1B at any time. The law also says it's at an institution of higher education and not employed by an institution or for an institution of higher education. So if NMSU or any other university has a research institution on campus or has another business on campus, any type of business which furthers the actual mission of the university, then you are employed at an institution of higher education, and that would also allow for the cap exemption. Now, of course, if you were to work for a government research institution, those are cap exempt, or if you were to be employed by a not-for-profit research institution, then the cap also does not apply. I always mention the cap exempt possibilities because visa numbers do run out every year. And then let's talk a moment about the cap versus the cap gap. And I assure you, I'm not making up these terms. Those terms are strictly, from the immigration lexicon. That's how it's all called. So we just spoke about the cap, but the cap gap, and after that, we'll talk about how to register for an H-1B. So the cap gap is actually something very, very good. Many of you already know, because of the limited availability of H-1B visas, they have to be applied for on April 1st to become available on October 1st. This is like with any other visa category. You can apply 180 days early. And the fiscal year in the United States starts on October 1st. So on October 1st, all the visa numbers become available, and that includes the H-1Bs. So if you want to apply first off, then April 1st is that day. You have to apply on April 1st in order to get started working on October 1st. Now, many of you already know that when you are in OPT, typically you graduate on or about May, so your OPT starts on or about May, and in May of the following year, you run out of OPT time. But if you applied for an H-1B visa, you would not have any status from May until October 1st, because that's when the H-1B visas will become available. And that's where the cap gap comes in. If you are in OPT and you have applied for an H-1B visa, and you have in fact been selected for H-1B visa processing, and you subsequently do run out of student status, out of OPT time, then the cap gap will kick in and you may remain in the United States until October 1st, and you're even allowed to continue working until October 1st, until your H-1B kicks in. So actually a great thing, that cap gap. Now, the H-1B application process has changed last year. Many of you already know that, if not all of you. In the past, we would have to apply on April 1st, and we'd send in tons of paperwork and then hope that our clients would all get selected. And typically, not always all would, because there was a 1 in 4 or 1 in 3 chance to be selected, depending on how many applicants shipped in the application. So the government actually did a good thing. And that is they implemented the H-1B application process. So instead of sending in all this junk and wasting all this paper and wasting all this time and work on H-1B applications that would then maybe not get selected, the government implemented a registration process. So I don't know how it's going to be this coming year, but this last H-1B season, we were allowed to register between March 1st and March 20th. And then there was a selection process, the H-1B lottery, on March 31st. And then if you were selected, then, of course, you had 90 days to actually ship in your package. So a very, very efficient and very pleasing process. And it worked quite well, I must say. Again, there are changes supposedly coming. We don't know whether the registration will be the same this coming season, since there has been talk in this administration to make the lottery based on wages that will be paid to applicants. I can't tell you at this point whether this is a lot of hot air. It sounds serious. I don't personally think that it will go through, but then again, I think I have an obligation to let you know that this is in the wings. We are hoping everything stays just as is. But what that tells you when you look at these dates, even though we can't apply for your H-1B visa until April, the registration period is likely going to be again in March. So if you are getting ready for an H-1B, now's the time to find your employer. Now's the time to make arrangements, because once that date rolls around, we got to register. We won't have time to start looking for a job at that juncture. This year, the registration was rather cheap. It only cost $10 to register. It requires an account, so our employers had to open accounts with USCIS. Of course, we have always assisted with this process. They don't ask for a lot of information. And they also wanted information about you, the applicant, your name, your gender. Don't ask me why they need your gender for a visa. I mean, you get an H-1B visa because you work in a specialty occupation, not because you have a certain gender, but leave it to our government to ask about that. Your date of birth, country of birth, and so on, country of citizenship, your passport number, typical biographic information. So nothing really to worry about at this juncture. So now let's assume that you have received an H-1B visa, you have found your way through the maze of registering and actually have been selected. You're ready to work in H-1B status. It's October 1st. That's when you find out that your H-1B visa has a 6-year limit. I mean, it makes no sense, but H-1B visas are limited to a 6-year time frame. And of course, there is a way around that, and I will teach you how to manage that. Then there is also something interesting, because the H-4s, those are the dependents, the spouses and the children of H-1B visa holders. H-4 time does not count against H-1 time. So I have had experiences with married couples where both have a specialty occupation, where maybe the husband works for 3 or 4 years in H-1B and the spouse remains in H-4, and then they switch. The spouse starts working in H-1B and the husband switches to H-4, and that way you can actually prolong your H-1B status if you are a married couple. Some of you know that at a certain stage, H-4 spouses have also received employment authorization. There are changes coming to that. That's unfortunately something that the current administration has undertaken by way of rulemaking. So they went the proper way with public comments and what have you. And it seems that the H-4 work authorizations might be going away. If they do, a new and incoming administration, if they would wish to change that, cannot do that by executive order. That would have to be done by way of rulemaking, and that would take at least a year, if not more, to facilitate such a change properly. Now, when you work in H-1B, as it happens in many positions, you might be there for a week or two or half a year, and you figure out, well, this is really not the place I want to be at. I want to move on. I want a different job. So what you can do with an H-1B, you can actually port to another job. But you can't just go and get up and move on to your next H-1B job. There is a process that you absolutely must adhere to. And please write this down, because if you do it wrong, your H-1B status is gone. So for example, if you work for employer A, and then you would want to switch to employer B, do not, and I repeat, do not quit your job with employer A until such date and time that employer B has filed your new H-1B application. You're not moving your H-1B, as you often hear out in the street. There is no such thing. The new employer has to apply for a new H-1B, and you have to requalify all over again. The employer has to qualify as an employer and your job, and you will have to qualify for the specialty occupation. The only thing that you do not have to fulfill anymore, you're not going to be counted against the numbers anymore, because you've been counted against the H-1B numbers already, so that is going to fall away. But you're not switching your H-1B from one employer to another. You are getting a new H-1B. And again, do not quit your job until that new H-1B has been filed for. That's what the regulations say. I always say wait until you get that approval notice. Why wouldn't you? So again, a word to the wise, do not burn any bridges with your current employers if you think of switching to another job, because you're going to need employer A until you're all set with employer B. Another reason why you shouldn't burn those bridges with employer A, and that is if for one reason or another the application at employer B goes bad, it's denied by the USCIS, you're still good with employer A. Your H-1B is still good with the original employer. So now we're going beyond the basics. I told you when we started out talking about the H-1Bs that there is a way to keep the H-1B beyond 6 years. And I think that's really a good thing. And that was signed into law. The law is called AC 21, the American Competitiveness Act of the 21st century, was signed, I think, around 2000 by then President Clinton. And it did some really, really good things. But it allows you to bring your H-1B beyond 6 years. And here's what you need to do in order to take advantage of that. You really have to time it. You gotta get this right. So an H-1B can be extended beyond its 6-year limit if either a labor certificate, and we'll talk about this later, or an immigrant petition has been filed for you at least 365 days prior to the expiration of your 6-year H-1B limit. So 1 year prior your 6 years expiring in H-1B, you must have a pending labor certification or immigrant petition. Please do not wait until year 5 to do that. There is a lot of red tape administratively with labor certificates and with immigrant petitions. There is no such thing that if you call me on Monday, Chris, we need to file a labor certificate because I'm getting into my 6th year, we gotta file it within a week. It will not be possible. To get a labor certificate filed, you're talking at a minimum 60 to 180 days before it can be filed. And it has to be filed to count for your extension on the H-1B. So if you have an H-1B, today is a good time to start talking about labor certificates or immigrant petitions, because there's absolutely no reason whatsoever for you to wait until the 5th year to consider permanent residence. Once you have an H-1B, that should be on your agenda immediately. And once that labor certificate is filed, and once that petition has been pending for at least 1 year, then your H-1B can be extended indefinitely to infinity until you get your green card in either 1 or 3 year increments, depending on the circumstance. But the good news is you will continue to remain here in valid H-1B status if you do this right. I think you will be getting a copy of this PowerPoint, and if for some reason you don't, then feel free to reach out to me, and I'll be happy to provide you a copy. Now the next visa is the O1, and I always talk about the O1 at NMSU for several reasons. Number one, because there are a lot of smart people at NMSU. And many of you qualify for O1s, and we have done many O1s for NMSU faculty and students. So I think that's an important part. But in order to get an 01, the other good news, by the way, is it's not subject to annual numerical limitations like the H1B. So I can get an 01 at any time. So, but you have to be among the very small percentage that has risen to the very top of their field of endeavor, which means you got to be the best in your field. And the fields are, you have to have extraordinary abilities in either the sciences, the arts, education, business, or athletics. You know, I would suggest to you in the athletics, it's pretty straightforward. Either you're a winner or you're not. In the sciences, it's pretty straightforward. Either you are published, same as education, and people cite to you, or they don't. It gets a little bit murkier in the arts and the business. And of course, as lawyers, we love that because we can write, you know, we can get more creative than in the sciences, education, or the athletics. But here are the prerequisites for an 01. Now, if you have been nominated for a Nobel Prize, or if you have won an Olympic medal, of course you are an 01, and you don't need to meet any of the other criteria. But if you haven't won any of those two, then you gotta meet 3 out of the following 8 requirements. You have received a lesser award than a Nobel Prize or an Olympic medal. You're a member in, you have a membership in an association that is distinguished, maybe something that you are invited to join. And let me be clear about that. If you are an electrical engineer and you join the Electrical Engineering Association of America, that is not any distinguished membership, because any electrical engineer can join the Electrical Engineering Association of America. So it'll have to be something higher up, this other distinguished association. You must have published something. If you don't publish, there's nothing extraordinary about you. So you must have published something in your field. If I go on Google Scholar and I can't find you, we are likely not going down the 01 route. If you have judged the work of others, that is something that is valued very, very highly. And by the way, being a TA is not judging the work of others. A TA would be considered judging the work of others if you have sole responsibility for the class. Then you are judging the work of others. If there's some original work that you came up with in your field, a scholarly authorship, of course, in education, publish or perish. I mean, there's nothing new about that. The work that you do is critical or essential to the business you are employed at. Or you're making a lot of money. I mean, if you're extraordinary and you're not being paid, well, maybe you're not extraordinary. So, but you don't have to meet all of those, but you have to meet at least 3 out of those 8 criteria. And we can get pretty creative on those. But 01s are typically not something that's helpful in a group discussion. That's really where we need to get to know an individual, where we need to learn about your field of expertise, where you gotta teach us what it is you do so we can get creative and help you achieve the 01 level. Very, very good, a great visa, really. Requires an employer. Now, I know that at NMSU, we have many students from Mexico and also from Canada. And that is, of course, something interesting because the treaty NAFTA visas and treaty dependent visas are only set aside for Mexican and Canadian nationals. You don't have to be born in Canada or Mexico, but you must hold Mexican or Canadian nationality in order to come within the purview of those visas. So there are 65 TN professions. So not every job qualifies. If you want to Google TN professions, they'll pop right up, for example, accountants or teachers in post-secondary institutions and up, nurses. So that's a lot of very, very interesting jobs. There's also a lot of agricultural scientific jobs, which is, of course, very interesting for NMSU, since NMSU produces such and interesting degrees in the agricultural sciences, more than many other universities in the United States, actually, and the TN really lends itself to that. So do Google that if you are Mexican and or a Canadian national. Now, other good news for Treaty NAFTA is, of course, that you get it between 1 and 3 years, and that it can be renewed indefinitely in those 1 and 3 year increments, because as long as you have that job offer. And when I say 1 and 3 year increments, that's really a reciprocity rule. The United States has a reciprocity agreement with Mexico, where if I, as a US citizen, apply for an FM3 visa in Mexico, I can only get it for 1 year. So that's why when a Mexican national applies for a visa stateside, they can only get it for 1 year. I mean, it's a dumb tit for tat, really. But that's the way it is. Now, with Canada, the TNs are typically issued in 3 year increments because, you know, Americans enjoy the same benefit under the agreement. So many of you know that Treaty NAFTA has been canceled under the Trump administration. It has been changed. It is now the United States-Mexico-Canada agreement, but I'm pleased to report that there have been no adverse changes to the TN profession. So if you are Mexican or Canadian national, and if you're interested in that, do feel free to reach out to us on that. Now, I know as academics you're familiar with the alphabet, but some would be amiss if I don't mention that we can talk about every visa category, but it'll take me about 2 minutes to run through the visas that are associated with each letter. And if you think that you might fall into one of those, you gotta let us know, because we can talk about all of those. But just to trigger your thinking about visas. So A is for diplomats, B is for visitors, C is for people in transit, D is for crew persons if you work on a cruise ship or for an airline, E is for investors and for traders or for professionals from Australia. F, of course, you're familiar with, those are the student visas. G visas are for persons who work for international organizations. So if you work at the United Nations in New York, for example. H visas we already discussed, but remember there's also H2Bs, there's H3s, which are training visas. I's are for international correspondence. J visas, you already know from NMSUs, those could be your scholars or even your students. K visas, if you have a fiance or a spouse, a K1 or a K3 might apply to you. L, an intra-company transfer. If you are working overseas in a business and you're transferred to an affiliate, subsidiary, or parent company here in the United States. M is, of course, a vocational student. N for NATO. O visa, we just talked about it. P, if you're an athlete or if you're a member of a, let's say, a soccer team. Q, cultural exchange. R, religious workers. S, that's the snitch visa. If you know anything about a crime that's been committed and you want to rat something out and you want to talk to the FBI, you'll get an S visa. Not a great visa, because once the snitching is done, they'll send you back. The T visa, more a tragic situation, that's human trafficking. We're glad to have the visa so we can help persons who are subject to human trafficking. U visas, if you are the victim of certain crimes and you are helpful to the authorities in order to solve the crime, you might qualify for a U visa. The V visa no longer exists. W is for visa waiver persons. If you come from a country that does not require a visa to visit the United States and there's nothing there for XYZ. So there you have it. If you can think of anything that you might fit into, feel free to reach out at any time. We're at the halfway point, and we're now switching from non-immigrant to immigrant. All the visas we just spoke about, they all have a time limit on it. So the H-1B, you already know, is 6 years, and it can be extended if you do it right. The TN visa, between 1 and 3 years. If the job goes away, so does the visa. Same with every other visa. Those are the non-immigrant visas. Now we talk about the IVs, the immigrant visas. And the immigrant visas, that's permanent resident. That's the green card. And there are two major categories: family green cards and employment green cards. On the family green cards, that's when you marry a US citizen. We're not talking about that today. We are talking about the employment green cards, because that's the categories most of you will fall into. And within those categories, there is a slew of categories. And if you think there were quotas under the H-1B, wait until you hear about those green card quotas that are out there. So this is what's called the visa bulletin. And I want to explain to you some of this, what it means, because it is something that will follow you. If you ever apply for a green card, it will follow you until you actually have your green card. There are 5 different categories. The first, the second, the third, the fourth, and the fifth. We are only interested in the first 3. The fourth and the fifth are religious workers, and the fifth are the employment creation visa. So if you got a couple of million to invest and you want to create 10 jobs, then let me know, then that's the category you fall into. But in academia, this is what you fall into, the first, the second, and the third. So those are the employment-based categories. Now here on top, what you see, first, all chargeability areas. So that's every country in the world except for those listed over here: China, El Salvador, Guatemala, Honduras, India, Mexico, and the Philippines. Let me explain what that means. In each category, 1 through 3, there are only a certain number of green cards available each year. And no country in the world may get more than 7.5% of these numbers. So some of those, and C means current, there are visa numbers available. But if there are more applicants than visa numbers available, then the category falls behind. And that creates these waiting periods. So if, for example, if you are from India and you apply in the second preference category with a master's degree, then the government currently processes May 15th of 2011. That is nearly 10, 11 years behind. Think about that for a moment. Can you see now how important it is that you get AC-21 correct? Can you see how important it is to have an H-1B visa beyond 6 years? Because if you are in from one of those countries, or China mainland born, it is important that you can extend your H-1B visa beyond the 6 years. Otherwise, you won't be able to get your green card. You can still get it, but you'll be waiting at home in India or in China, if that were the case. So those are the visa numbers. So that's different categories, different preferences, all depending on how many applicants are actually applying. Now, what we want to talk about is, again, the EB1, and there's 2 categories we speak about, the EB2 and the EB3. EB stands for employment-based, just like it is indicated here in the visa bulletin, employment-based. You can find this visa bulletin online. Just Google visa bulletin, it'll be all over. Make sure you look at the right thing. You gotta be from the Department of State. And this is published every month, and you can look up the employment-based numbers. Because when you file a labor certificate or an immigrant petition, and we'll talk about how that works, the day you file it, you will get what's called a priority date. And that's the date that needs to be published in here for you to get a green card. So again, we'll talk about employment-based first, employment-based second, and employment-based third. In order to get any of those green cards, in most cases, your employer will have to file a labor certification. Most really need it, but some do not. A labor certification is the most classic way to immigrate to the United States. It is where an able, willing, and qualified and available employer will petition for you because that employer is unable to find an able, willing, qualified, and available worker in the area where his or her business is located. So the whims of the marketplace are the most important thing. There's got to be a job opening and the employer can't find anyone. And here's what the employer has to do in order to qualify. The employer has to offer a full-time job. Remember when we spoke about the non-immigrant visas, with an H-1B, you could work part-time. With a TN, you could work part-time. With an OPT, you can work part-time. On a labor certificate, when you get that job offer, it has to be a full-time job offer. And our Department of Labor, for labor certification purposes, defines full-time at 35 hours per week. It has to be a bona fide job offer, meaning it's not somebody doing you a favor. The job actually has to exist. In addition to that, the job cannot be tailored to you. So let's say you are a Mexican national and you live in Guadalajara. The job advertisement cannot be, I want to hire this person. They got to speak Spanish. They should preferably be from Guadalajara and they should be a Mexican citizen. No, it doesn't work that way. The job cannot be tailored to you. That means the job has to be open to American citizens so they can apply for the job. The employer can put in a business necessity. A business necessity, for example, could be a language requirement. That business, if that employer deals exclusively with a Spanish-speaking market, well, then of course my staff has to speak Spanish, because if they don't, then I'm going to go out of business because they don't understand what my customers are saying. So that would be a business necessity. But just saying that I need someone who speaks Spanish, that's not going to do it. We will have to prove to the Department of Labor that the majority of communication within that business is actually conversed with in the Spanish language. The next thing the employer has to do, they have to ask the Department of Labor about a prevailing wage determination. And again, there are some changes again. Remember on the H-1B, I told you that the Department of Labor is about to raise those wages to the ceiling for H-1B workers. They are talking about doing the same in the labor certification process. Have we seen that yet? No, we have not. So hopefully that is not going to happen. And then, of course, the employer has to demonstrate that there are no U.S. workers who are able, willing, qualified, and available where that business is located. So if that job offer is in Las Cruces, well, then of course we'll advertise the job in Las Cruces and not in Denver, Colorado, or try to bring someone in from New York City. No, we only have to advertise where the business is located. And I again put changes there, and this is really more of a personal observation, what I'm noticing with labor certificates. There's obviously, I think everyone has realized that the American economy has really taken a turn for the worse because of the health crisis we find ourselves in. And that has caused fewer employers to hire foreign nationals, and has therefore caused fewer employers to file for labor certificates. There's good and bad news for us in that. The good news is, if there are fewer labor certificates filed, well, they will be processed quicker because the Department of Labor doesn't have as many applications, and it will undoubtedly have an impact, a whip later on the visa numbers. I think the visa numbers that you saw in the visa bulletin are going to catch up in some of those categories that are oversubscribed because there is fewer applications coming in, and the ones that are in the line are getting their green cards. So those are the good news. The bad news is that the Department of Labor has begun auditing labor certification applications at more than half of them that are being filed. And you can imagine that the scrutiny is a rather tough one, given the fact that there are so many unemployed persons in the United States. The Department of Labor really wants to know whether that employer has done proper recruitment to weed out all applicants legally. So that's a category where you don't need a labor certificate, where you can actually petition for your own green card without doing anything else. And that's a really cool thing. It's very, very similar to the O visa. If you look at it, only this is permanent and the O visa is temporary. And here you don't need an employer. Again, it's persons of extraordinary ability in the sciences, the arts, education, business, or the athletics. And very, very similar to the O visa, you can see those categories. If you recall, under the O visa, we were looking for 3 out of 8. Here we're looking for 3 out of 10. So I'm assuming you don't have this Nobel Prize or this Olympic medal. So there you go. Here are your categories that you could take a look at. And if you qualify, you can get a green card. And again, the EB1 is really doesn't lend itself to group discussion. We really have to get to know you to determine whether you come within the purview of the EB1. And, you got to have a pretty open mind on it, because, many things are possible. And I always ask this question, what these three have in common: the spine surgeon, the perfume bottle designer, and the mountain biker. Well, I'll tell you, I got EB1 green cards for all three of them. So you can see this is in every discipline, and it depends on what it is. If we can flush it out, we'll be the first ones to tell you, hey, you do qualify, or it doesn't look this good. Let's look for something else. So the EB1 is definitely something you want to keep in mind, because you don't need an employer. But also remember, you have to be at the top of your field of endeavor. You're the very small percentage that has reached that top of the field of endeavor. The EB1 too is, of course, a great green card, and we have done plenty of those for Nmsu, of course, because you do have plenty outstanding professors and researchers at your great institution. And similar to the EB1, just a little different. You need 3 years of experience in teaching or research in the academic area, and then you meet 3 out of the following 6 requirements. So that's an interesting thing. Faculty very, very easily comes often within the purview of that. That's a category you have to take a look at, because I will suggest to you that the majority of you will come within the purview of the EB2 category, the employment-based second category. And the employment-based second category has 3 distinct subcategories. There is a category for advanced degrees. And as I said before, advanced degrees is everything of a master's or higher, or persons of exceptional ability, not extraordinary ability, exceptional ability, and persons who qualify what's called a national interest waiver. Now, quickly, the 3 of them. The most common one is the EB2, where you have an advanced degree. And with an advanced degree, you need an employer, and the employer can file the labor certificate for you. However, you got to keep in mind that having the degree is not enough. The job must actually require your degree. Just having it makes no difference. So let me go back to the example of the electrical engineer, because that would be an interesting example. If you have a bachelor's degree as an electrical engineer, you can get an H-1B visa, can you not? If you have a master's degree in electrical engineering, you can get an H-1B visa. Without a doubt, you fall into the 20,000 exception category. But can you get a green card with a master's degree in electrical engineering? Well, I will suggest to you, maybe, because the job actually has to require the master's degree. And it's not your employer who will tell you whether the job requires it, it's the Department of Labor who will make that determination. And if the Department of Labor says the job in this particular area, a bachelor's degree will do it for the electrical engineer, then the master's degree is not a requirement we can ask for. Then I can only ask for the bachelor's degree. There is something that you must understand about the labor certificate. Clients and employers always come to me and say, I want this guy or I want this lady because she has 15 years of experience in exactly what I need. She knows how to build that mold and do it right, and she puts the right chemical components together, and we make these great figurines, and I need her because she's got 15 years of experience. Well, I got news for you. The Department of Labor said 2 years of experience is enough. Why? Because you have to give the American workforce a chance to apply for the job. So the Department of Labor tells us on a labor certificate what the minimum requirements for the job are, not the maximum wish list that the employer has. So when we go back to the electrical engineer, a regular engineering company, well, maybe the supervising engineer needs to have a master's degree. Maybe the team leader needs to have a master's degree in electrical engineering, but all the other engineers, a bachelor's degree may be enough. So keep that in mind when you're on your job search, or we'll be happy to evaluate it for you to see whether your master's degree comes within the right purview of that. Exceptional ability is an interesting thing. I've never been able to determine the difference between exceptional ability and extraordinary ability. I mean, if you know, then let me know. But it's a degree of expertise significantly above that ordinarily encountered. And then you meet 3 out of the 6. We have done plenty of those. It's a very, very interesting category. Again, you know, if you have a related degree, that's great. Or you could have 10 years of experience in something that makes you exceptional, and you might not even have a degree or not need a degree for it. You make a lot of money, or I'll have a special license for something, and so on and so on. So those are things, you know, we have to take an individual look at. I'm just throwing it out there for you so you know that this category exists. And then the national interest waiver. This is something I get many inquiries from NMSU students on that when they think, can you determine for me whether we are working in the national interest? And here, you know, this is an interesting thing, but whatever you do has to be in the national interest and not for the benefit of some geographic locale. Anything to do in healthcare, let's say COVID-19 related, would be in the national interest. Not you working as a COVID-19 nurse at the hospital in Las Cruces, but if you are a COVID-19 researcher, that would be in the national interest. The nurse would be in the geographic local interest. So that's probably the biggest mistake that I see when I get inquiries about national interest, is the endeavor that you are in really in the national interest, is the invention that you made in the national interest. Your research assignments and the grants that you have received, is that resulting, what your research results are they in the national interest? If you're in transportation, is in logistics, is it geographically limited, or is it in the national interest? So that is something that's interesting. It requires an employer, but it does not require a labor certificate. So we can go right to the green card. And then finally, you have the EB3 category. That's professional, skilled, and unskilled labor. And that's anyone with a bachelor's degree. So if you have a bachelor's degree and you have an H-1B today, you qualify for the EB3 today. And don't think that this is a lower level. No, most people really apply for their green card in the EB3 category. It's the most common way to get in. And if you look at the visa bulletin, the EB3 category is even further advanced. Let's just go back to take a look at that. I'm trying to work this PowerPoint here. I promise you my legal skills are much better than my technical skills, but give me a moment. There we are, and then let's blow this up again. So look at that for a moment. Let's take the country of India. And here, in the second preference category, the priority date is May 15th, 2011. And in the third preference category, where you only need a bachelor's degree, it's May 1st, it's January 1st of 2015, almost 4 years ahead. So the category, you know, the higher the category does not mean the faster you're getting your green card. That is not the case. So the EB3 category is not a bad category. I want to take a moment to talk about some other considerations, things that I see. Everyone applying for a non-immigrant or immigrant visa has to fill out an application at our consulates, either a DS-160 or DS-260, depending whether it's non-immigrant or immigrant. There are new questions on there, and one pertains to your social media accounts. And you have to disclose all your social media handles for the past 5 years. And please don't lie about that, because they'll find out. They already know. And they become a consideration in your visa issuance. I'm telling you right now, clean up your social media. If you are applying for a student visa and your social media account is full on how you're going to work in the United States, that'll be the end of your student visa. If you're on some other non-immigrant visa that doesn't allow you to do certain things, don't talk about those things on your social media. Keep in mind, different countries, different customs. What we think is funny in the United States may not be funny in Saudi Arabia. What you think is funny in Iran may not be funny in the United States. What sounds great in Brazil may not sound good in England. So be careful about the opinions you have on social media. Be careful on who you sympathize with on social media. Do you know what sympathizing means? I will go as far as to tell you liking something is sympathizing. So be careful on what you do online. I have seen more visas denied based on comments on social media that have been misinterpreted for being a potential terrorist act, for being a potential terrorist comment, for insulting something that in that country does not qualify as an insult, or something that would not qualify as an insult in the United States, but in that country it is. So just a word to the wise: clean up your social media before you apply for a visa or before you apply for a green card. There's some other considerations also with the new public charge rule, a very, very bad rule. There are changes all the time. It has once again been stopped by a federal judge. So right now we don't need it. Next week we might need it again. I think there have been 3 or 4 injunctions against the new public charge rule ever since it has been enacted less than a year ago. It is a very, very, very painful thing. But if you apply for a visa, make sure you get your finances in order. Make sure your documentation is in order, because we will have to submit it. I think any other discussions about the new public charge rule is a little outside of this presentation, but I think I wanted to mention it because I see it popping up and I see it become a hindrance in many visa issuance cases and in many green card cases. And by the way, even extensions of stay and changes of status, the public charge rule does apply. And finally, I want to alert you to the I-94 situation. In the past, as you know, you got an I-94 when you entered. Now you get your I-94 electronically. Here on the left side of your screen, this is typically the stamp that you would get in your passport when you enter in F1 status, duration of stay. So that is not noticed though. The I-94 is. Every time you enter the United States from outside the United States, please go online and get your I-94. All you need to do is Google retrieve my I-94. It'll pop right up, enter the information from your passport, and then print out that I-94. It's also important that NMSU's HR department has your current I-94 when you return from overseas, because that is the document that determines your legal stay in the United States. And now I'm getting ready to answer your questions, but I gotta take a minute to figure out how we do this. So let's see. All right. I got some that I got in the chat, so let me go through those first. From Sangwon Lee, I was hired as an assistant professor and I have an H-1B. Congratulations, that's great. And as you recommend, I want to apply for a green card ASAP. Then what is the next step? Whom should I contact? Contact your department head if the university is if the university is willing to hire you, then that is what you ought to do. As you know, Tim Reardon in our Albuquerque office handles all these applications. He can get it off the ground for you immediately, but of course you need NMSU's okay, because remember that the green card application is not an application that you file, it is an application that NMSU files for your benefit. So you need to talk with your department head first. From James, thanking us for the presentation. Thank you, James. That's very kind of you. My wife is a nurse and she's on an F1 visa. She's preparing to write New Mexico Board of Nursing license exams. Congratulations, that's wonderful. My question is, after she's certified, does she have to change from F1 to F2 before she can work? She'll have to do more than that. She will actually need a work visa. The F1 will not allow her to work as a nurse, and neither will the F2. F2s do not get employment authorization. The best way to work as a nurse is actually by way of a green card in the EB3 category. Nurses are exempt from labor certificates because the Secretary of Labor has already determined that nurses, that we have a shortage of nurses, so the green card can be applied for. Depending on what country you're from, if you're within the all chargeability areas, those are current right now. I strongly encourage you to reach out to us so we can lay the groundwork for that, because there's quite some paperwork involved in that. But congratulations, this looks like a great career. Next question in the chat was, I'm doing my PhD, and that's from Amer. I'm doing my PhD and I'm working into my entrepreneurship project based on my PhD research. I went through the NSF and Corps, and I will be applying for SBIR funding to start my own startup company with my advisor. Not sure if we can have it inside NMSU or affiliated with NMSU yet. But my question is, can I apply for OPT to work in my startup company as long as I'm receiving the funding? Yes, you can. With OPT, you can be self-employed. Remember, it's only good for 1 year. And as long as your work within your own startup is a function of your PhD, and of course, I can see here that it is. Next question is from Kofi. I'm an H-1B holder and I got a new H-1B approval. Congratulations, Kofi, that's great. I want to extend my I-94 and I visited the Customs and Border Protection at the Albuquerque International Airport for I-94 extension. I'm not going to read the rest of it. That's not how it works. It's done completely different. Again, that has to be applied for with the USCIS directly at a service center. That cannot be done at the local office. Please, Kofi, reach out to us. We'll be happy to walk you through that. By Yuan. I receive a job offer from a university. However, I do not have a valid visa status. My OPT expired in July. I applied an extension in May, planning to leave when the pandemic is over. Right now, my employer wants to apply for an H-1B for me, but they find I do not have valid visa status. Quite frankly, Mr. Wang, I do not understand the question. I can't ascertain whether you are in status or not. I strongly encourage you to reach out to us. We need to look at the documents that you have and the extension that you filed in order to see whether you are eligible to file for a change of status, or whether we would have to apply for something in your home country. And then, of course, I would have to know what national you are, because that could cause another hurdle on that. An anonymous attendee, hello, I'm from Mexico. My F1 visa expired this month. Can I still travel to Mexico if my I-20 is still valid for 1 more year? Yes, you can. You have to return within 30 days, though. Do not stay longer than 30 days. Thanks for the presentation. You're very welcome. Many publications do I need for an EB1? Mohammed, I can't tell you how many publications you will need. It'll boil down to the quality of the publications, whether those are shared publications or whether you're the sole publisher of those publications. We'll be happy to at no cost to you, take a look at your resume and your publication list and give an affirmative answer on that. Again, Mr. Wang, you're asking me a specific question about a pending review at the Immigration Service. I would need to see all the documents in order to give an intelligent answer on that. Mayor has a second question. If I apply for NIW, which is National Interest Waiver, before getting my OPT, will that affect my OPT application approval while the NIW I-140 is pending? Or should I wait? No, get the OPT first, because one is a non-immigrant and one is an immigrant visa. So don't do that, because that will go by the wayside. I do not recommend that. Let's see if I can see some other questions here. Someone is asking whether I can post my contact information in the chat box. I'll be happy to do that. What I will do, I will give you the email of my personal executive coordinator. Her name is Liz Pavan, because that's the safest way for me to actually get it. And her email is make sure I have no typos in there. That is it. I'll be happy to give you my personal email as well. But I do encourage you to write to Liz. I will assure you that the communication will be more efficient if you do that. I would also ask, when you write to me, in the subject line, reference that you were a guest in the NMSU presentation. So we can track that, and that way you will get our immediate attention, since we provide the service extra for all of our NMSU students. And with that, I see that we have no more questions. So I thank you for participating today. I know these are very troubling times. Everything has become rather complicated, but we have found our ways to get through it. And if we can assist you in any way, we'll be happy to help. And it's been great to presenting to you once again. And I shall all see you in the spring, maybe even in person. And if not, then again here online. Goodbye.